An Illinois Appellate Court upholding a temporary restraining order blocking enforcement of Illinois' gun ban, that happening today out of the Fifth District Appellate Court from the case out of Effingham County. This was the case that attorney Thomas DeVore brought several weeks ago, arguing in an emergency hearing that the measure violated 866 of his plaintiffs' rights on several counts. Now, DeVore argued that it violated the state's single subject rule by passing it under a bill with a different name. The court threw that out. The court also threw out the 3 readings rule violation that was alleged. Another violation that was alleged was due process. The court said that that wasn't founded. However, count 4, the violation of equal protections, is founded. I talked with Thomas DeVore about this, and here's what he had to say.
The appellate court said that as far as likelihood of success with the record that they had in front of it, they found equal protection violation that was a likelihood of success. It doesn't mean that the other arguments that we've made won't be successful. They just said with the record they had in front of them, they couldn't say that that's been established. And I'm okay with that because we've got some discovery and other things that we've got to go through to really lay out those procedural issues. And the appellate court's ruling, they take them to task on all of those procedural issues, so they understand them. But as of right now, at this very preliminary stage, the appellate court said equal protection is the problem. And when you and I have talked about this in the past, Greg, I always said in the short term, absent the record being fully vetted and generated, equal protection was by far the most pertinent argument in the short run. So the appellate court agreed with us and said that the TRO stands because there's been an equal protection violation.
For the layman out there that doesn't understand the equal protections argument, just lay that out there.
Sure. I mean, the equal protection argument is that this law carves out 7 categories of people based on their profession that they're not bound by this law. They can buy all the AR-15s they want. They can buy all the 50 calibers they want. They can buy all of the 30-round magazines they want, purely based upon where they work. Current retired police, prison guards, county jailers, security people, and the government tried to argue that that was based upon their extensive training. That was the reason that they were able to be carved out. And there's a lot of problems with that, Greg. One is that does being trained further the purpose of this law? That's a fair question. And second and most importantly is, then if training is the issue, truly the issue, then every citizen in the state of Illinois should have the same opportunity to take some comparable training as to these categories of professions and retain their rights. And so, we argued both of those in this case, that one, this is not about training. It has nothing to do with training. It doesn't make any sense. And to the extent it is about training, we have a right to then seek that training as well as citizens and not lose our right to purchase and possess and not register these weapons. We just go take the training that they think is reasonable. And again, the appellate court agreed with us, at least in the interim on that issue, is that when this court entered this ruling, that there is right now a likelihood that this law violates equal protection, that opinion would be binding on every circuit court in the state that might choose to consider this issue. So if somebody files a case in Sangamon County with the circuit court saying that injunction should issue because you're violating my equal protection rights, that circuit court case or court is bound by that opinion. That's what that means, if that makes sense.
Also at the Illinois State Capitol, I was able to connect with several state representatives. State Representative Maura Hirschauer argued in favor of a weapons ban.
We've been expecting kind of any twist and turn that can come, so I feel really confident that we have passed the best bill we possibly can and that our attorneys are ready to fight it and still feeling positive. I think I stand with my constituents who are tired of waking up every morning to hear about another mass shooting, whether it be in our state or in states across the country. We took a stand here in Illinois that our constituents wanted us to, and I'm proud of the work we did.
Also talked with State Representative Dan Calkins. He has a similar case in Macon County.
I think it's great news. Congratulate Tom DeVore for getting this in and being able to defend his case in the appellate court. Now we'll see what happens in Effingham in the courthouse. is it going to go to trial? And if it goes to trial, how that works out. But I think it's good news. It's a good sign. Hopefully, it'll have a big impact on how we do business here. I don't think I can figure out what a judge is going to do. Every case is different. Our case is a little different than Tom's, but it follows the same track. We'll see 1:30 on Friday what the judge is in for. Generally, I've been told judges don't like to go against another judge in the same circuit. So we're very hopeful that we'll get a positive response from the judge.
We'll, of course, keep you updated on all of these cases and more as we look at a variety of cases in federal court as well as state courts. A lot of moving pieces in the legal challenges against Illinois' gun ban. Be sure to tune in 6 to 9 weekday mornings right here with Bishop on Air.